afternoon and welcome to Law and Crime. I'm Angelica Spanos. Thanks so much for joining us today. All right, so this is the first part of these interview tapes that we're hearing between Cruz and a police officer here. You hear him starting to describe how he says he's been hearing these voices. He says the voice is a demon in his head. He even said that the demon or the voice told him to buy the AR-15 that he used. So a lot of details coming out in this interview. I'm going to bring my guests in here one by one right now. First off, Mike Koribanics, Law and Crime legal analyst. Mike, what'd you think of this confession? How the cop was asking the questions? What was the dynamic like between these two in that room?
I was appalled by the officer's conduct in this interrogation. I think it was way off base. I think it was wrong. I think he showed he's inexperienced. They're looking for a confession and a gathering of facts. This officer, I thought, was way out of his lane by giving his opinion, talking about the voice, things of that nature. That's for a jury to decide and for the attorneys to argue. He's not there to show that he's smarter than this young man. I mean, obviously this person committed horrendous acts, and the facts there weren't in dispute. Now he's going out of his lane to talk about psychological effects, talking about the voice. I just thought this was not good, and I can't imagine the prosecutor's very happy because of what they're going to have to do with this tape.
All right, and at this point, he wasn't even arrested yet either, so that's also something to keep in mind. Also with us today, Bob Hille, trial attorney. Bob, you know, we hear about the voices and, of course, all these things having to do with his mental state. Does this sort of touch at them potentially maybe exploring the insanity defense, do you think?
Well, I think you have an individual that it's clear committed the offenses that are either charged or going to be charged. So the question is going to be, what is his defense going to be? And the state has to address, if there's some doubt in the jury, whether or not an insanity and or hallucination defense, which is also a defense, it doesn't exist. So the officer here is certainly exploring facts. I mean, you're going to have expert opinion, the charges that the jury get talk about expert opinion. But right now he's trying to determine, you know, is a hallucination going to be part of the defense? The mental illness part will be something that other people are going to supply on that.
All right, Bob, thanks. Also with us today, Joseph Scott Morgan, forensic death investigator at Jacksonville State University. Joseph, good to see you today.
Hey, good to see you too, my friend.
So let's talk a little bit about this, this case in general. Obviously, forensics are going to play a part in this trial.
Yeah, they will. And going back to my colleagues, you know, it kind of starts trying to unfold the story, and it's happening in the interview process initially. This is kind of my rule of thumb. Anytime I listen to an interview tape and I hear the cop talking more than I hear the suspect talking, that's a problem, because I'm not interested in hearing what the cop is saying. Going to training, the idea is you try to endear yourself to this individual. You try to have some kind of connection with them to have them open up a bit and begin to talk about what's happened. I want to assess the situation to begin with as an investigator to find out if there are any more threats out there and find out exactly what's going on. I mean, for all I know, if this guy has gone to this much trouble to just go in and attempt to wipe out everybody in the school, I want to know if he's got any kind of secondary explosive devices. I want to know if his home is booby-trapped, all these sorts of things. But that only starts with the first step, and the idea is to try to get him to talk to you. And, you know, at this point, this guy is just kind of rambling on, and I have a big problem with that. The forensic stuff will come. It'll come eventually, and you'll have all of these tiebacks relative to the weapon, the spent casings, and his movements. But the key here is to get this guy to talk.
All right, so this is another part of the interrogation video that we're seeing. We hear Cruz talking about his computer, any potential pictures with guns. He was being asked about a comment that was posted on an online newspaper that said someone named Nikolas Cruz said that he is going to be the next school shooter. We also hear him talk a little bit about cutting himself and self-mutilation. So a lot of other details coming through in this part of the interview. Let's talk about this. Mike, as far as we know, this interrogation has not been thrown out. So the jury, as of now, will see this interview. How's that going to play into all of this? Because as you said before, you're not thrilled with how this went down.
Well, you know, this is not a game. I mean, we have a horrible shooting that occurred here. This defendant is, charged with one of the most horrible shootings we've ever witnessed, yet they come at it in such an amateur way. I mean, really, you would want the guy, this defendant's committed to a mental institution. You have a police officer coming in, speaking to him, not aware of his rights. I don't know how this is going to play out. I don't know if there's been a final ruling, but I will be amazed if this gets in before a jury.
Right, we'll have to wait and see. And the reason why we're talking about this, as I said earlier, is because the defense filed this motion to say the death penalty needs to be thrown out in this case. Bob, do you think they'll be successful with that?
Well, I think they'll be successful. I think the law in the application is pretty clear in terms of throwing out the notice that the state gave. It's clearly defective. I mean, there are elements in the aggravating factors that don't even apply to this case, government status and things of that nature. So that part of it, I think they're going to prevail on. But I think what's going to happen is the statute that is in play here is going to allow the court to have the state go back and correct its mistakes and really identify and drill down here what those aggravating factors are that they believe they can prove in this case beyond a reasonable doubt.
All right. And let's talk about the behavior of Cruz in this. Joseph, you mentioned, or you know this well, talk about his behavior during this interrogation, how his posture, how he's sitting, all of that. What do you think when you watch this?
Yeah, if you'll pay close attention to his hands, he stares at his hands and he kind of soothes himself by rolling his fingers back and forth. Sometimes you see this in Parkinson's patients. This is referred to as pill rolling. I don't know what he's got going on necessarily. He's having very difficult time making eye contact with this individual. He'll dip his head. He'll kind of recline, almost like he's not fully aware. And so going back to what was earlier stated in regards to this fellow, I don't know if he's all there as far as maybe the vacant sign should be on. However, we have to keep in mind, and the court certainly will, and prosecution will be aware of it. He was well aware enough to go out and purchase this weapon and kill 17 people as well as injure 17 others. So that's going to be an uphill fight for the defense.
All right, thanks, Joseph. And you mentioned purchasing that weapon. In the next part of the interrogation, he mentions how he got the gun. Let's listen. All right, so here's Cruz answering questions about the gun. And while he's answering these questions, he's able to think through these, answer them very thoroughly, and pretty much comply and give everything this detective answers that he's asking for. Bob, how's that play into this? Because I know this is going to show that he is sort of in his right mind here, right?
Yeah, the ultimate question is it going to be evidence, and is it going to be evidence to show that? So the court's got to struggle with a couple things, as Mike and Joe talked about. Number one, the ability of this individual to exercise even his Miranda rights. I mean, he's answering questions, and we haven't heard anything about whether or not he was advised to those. The conduct of the investigation, we heard too, whether it's overreaching or not. And then the value of what's being extracted. If the officer's talking, you're not really getting any value maybe from the defendant. So those are three things in terms of deciding whether the jury can look at this. The court's going to have to wrestle with.
All right, Bob, thank you so much. We're going to take a quick break right now on Law and Crime. Plenty more after this. Stay with us.